Good morning, ladies and gentlemen. My name is Rhamy Jill, and welcome to the People Processes podcast. Let me start off by telling you about a company in New Jersey that had a perfectly good employee handbook, solid progressive discipline section. It had a verbal warning, written warning, final warning, then termination. Clear steps, fair processes, professional. They looked at their table of contents, they confirmed they had policies for everything they needed. Then, they fired an employee without following that progressive discipline section. The employee sued. The company's lawyer pulled out the at-will disclaimer, which was on page 1, and said, "This handbook is not a contract." The court looked at page 1, then the court looked at page 15, the progressive discipline section, and said, "Yes, it is. This is not at-will employment. You have a contract because of this progressive discipline section." The employer lost. Their handbook said, quote, "Employees will receive a verbal warning, then a written warning, then a final warning before termination." The word will, not may, or will, barring company discretion, not generally, will. And the court ruled that that word turned a policy into a promise, a contract, invalidating at-will employment. Here's what I need you to hear. Your employee handbook might be a binding contract right now, and you have no idea. Today I'm going to show you the 6 words that create contractual obligations, why your at-will disclaimer may not save you, and the 5-step audit you can run this week to protect your business. So, first up, why do courts treat handbooks as contracts? Most employers think handbooks are internal policy documents, operational guidance, not legal commitments. But courts in multiple states have ruled otherwise when 3 conditions exist: specific promises, weak or missing disclaimers, and inconsistent application. The legal theory is called implied contract. Even without a signature on a formal agreement labeled employment contract, the handbook creates an implied contract based on the employer's representations. Just like if you verbally promised an employee 1,000 times, "This is your place forever, I will never fire you." Or if you've told them, "I promise you next year you're going to get X raise." Those sorts of promises create contracts. And the handbook can create one as well. A couple cases, if you want to check them out, Woolley versus Hoffman LaRoche out of New Jersey is a progressive discipline policy that was a binding contract, the one I talked about at the beginning. Toussaint versus Blue Cross, termination only for cause language in the handbook was considered enforceable, even though there wasn't a standalone contract to support it. The more specific and mandatory your language, the more likely a court is going to treat it as a contract. So, what language creates that implied contract? Basically, 6 words that you need to search for in your handbook right now. First word, will. W-I-L-L. Employees will receive a verbal warning. That creates a promise of a specific procedure. Then search for always. The companies will always provide a permanent, unchangeable commitment. Shall. Managers shall conduct annual reviews. This is a big deal. I see this in performance review sections all the time. Managers shall conduct annual reviews. That's a legal term of obligation, binding. Anytime you see the word permanent, permanent employees are entitled to. That defines permanency. It directly undermines at-will status. Obviously, guaranteed. All employees are guaranteed. That's explicit contractual language. And of course, promise. We promise to provide. That's an overt commitment. So I want you to go search will, always, shall, permanent, guaranteed, and promise. Replace will with may or generally, always with typically or in most cases, shall at the company's discretion, permanent, use regular or current, guaranteed, use eligible for or may receive, and the word promise, you just need to delete that one, all right? Don't use that word, okay? So before, employees will receive 15 days of paid time off per year. Change it to eligible employees may receive up to 15 days of paid time off per year at the company's discretion and subject to change. People look at this and they think that's crazy. The very first page has a disclaimer saying this is an at-will agreement, not a contract. We're not making any promises. They get a false sense of security out of that. They think that at-will disclaimer covers them, but it probably doesn't. I mean, it can, but there's a 3-part test that the courts have looked at many times. The first one is conspicuousness. Can the employee actually see it? Will they see it? If you have an intro letter at the front and buried in paragraph 3 of the introduction in normal font with no special format, it says, this is an at-will agreement. There's never, this does not enter a contract, no promises or guarantees, blah, blah, blah. Won't work. Passing would be on its own page, in bold, clearly separated with a separate signature line. That's your best practice, a dedicated page, standalone acknowledgement, employee signs, and dates. Another place that fails outside of conspicuousness is specificity. Failing would be employment is not guaranteed for any duration. That only addresses duration, not procedure. So the words should be something like, this handbook does not create a contract of employment of any kind, express or implied. No policy, procedure, or statement in this handbook creates any contractual obligation. The key is that it must cover duration and procedures and policies, and oftentimes it only covers one or two of those. Then, this is the part that gets you in trouble, consistency. Does the handbook match? If the disclaimer says at will on page 1 and progressive discipline says employees will receive 3 warnings before termination on page 15, you will fail. It does not count. A contract that is internally inconsistent, disclaimer up front and then down here at the bottom, creates commitments. It's going to come down to the judge, but many, many, many cases have found that internal inconsistency favors the employee. So you got to make sure all your policies use that permissive language, may, generally, at the company's discretion, consistent with that at-will disclaimer. If the court sees a conflict between the general disclaimer and the specific promises wins. I'm going to have trouble with this case name, but it's called Duldaloo, Duldulao. It's that versus the St. Mary of Nazareth Hospital out of Illinois. The court found no implied contract because their disclaimer was clear, conspicuous, and consistent with the rest of the handbook. That's where they wrote these things out. Proper disclaimers do work, but only when all 3 factors are present. Even if your disclaimer passes the test, there's the 4th factor, though, that can kill you. So let me tell you a little bit about this last one. The final bit to make sure you're going to be able to utilize this handbook as a positive and not create a contract by accident. And that is consistency. If you have a policy in your handbook, but don't follow it consistently, you've created one of 2 problems. 1, you followed the policy for employee A, but not employee B. That's a potential discrimination claim. We've talked about that in other episodes. But 2, and perhaps more commonly, I see especially in small businesses, you wrote a handbook or you got a handbook offline, you put it in, and then you never followed the policies. Then you decide to enforce it. The employee argues it wasn't really the standard. So this is actually from Reddit. It's a recent post. It's a real HR professional. A new boss came in and picked up their 2020 employee handbook and then starts enforcing every policy in it. The problem is nobody has followed those policies for years. Employees are blindsided, HR is caught in the middle, and here's the legal problem. If you spent 5 years not following your progressive discipline policy and then suddenly fire someone using the exact process, a plaintiff attorney is going to say that policy wasn't really your policy. That wasn't your standard. You're using it selectively. And selective enforcement is evidence of something else, whether that's discrimination or retaliation. Take your pick. What would that look like? You have a progressive discipline policy, but manager skips steps for some employees. PTO accrual is listed in the handbook, but tracked differently in practice. There's a dress code in the handbook, but it's not really enforced until it's used against one specific employee. Attendance policy is applied differently across departments. Here's what needs to happen. You need to understand first, you need to audit your handbook against actual practice. If it isn't being followed, you need to, if you're going to decide I want to follow that consistently, you need to reissue and get updated signatures and say, okay, hey guys, as of now, we're following our handbook. Here's our handbook. Read it. Make sure you know, because we're going to start following this stuff. Give that same notice you would to a new hire. Or remove the policy or change it to match your actual practice. Okay? So that's an important piece to think about. Now, the last thing is, while you're in your handbook, there are some state-specific requirements that change every year. And if your handbook is missing, is like more than a year old, you're probably missing some. So I want you to take a minute to also make sure that you're addressing the state-specific requirements in there. Just because we're in there, I know this isn't necessarily relevant to the contract angle, but there are a lot of changes just in the last 2 years. California's got multiple reproductive health rights notices, off-duty cannabis protections, bereavement leave expansions, pay transparency requirements, Pregnant Workers Fairness Act accommodation notices. New York's got updated sexual harassment policies, pay transparency. Illinois has Paid Leave for All Workers Act, pay transparency. Colorado's got family leave updates. There's just a ton of stuff, okay? So as we talked about in episode 73, multi-state hire, if you have remote employees in other states or you happen to have actual physical locations in other states, you need handbook provisions that comply with that state's law in every case. Not just your headquarters state, every state when you have employees. So I want you to take a minute, if you're going to be doing a handbook review anyway, and make sure you have addendums or sections that apply to the correct states, the correct policies. It's very difficult to write a handbook that applies nationwide. Most people have a federal section and then one for each state for the employees who are based there. Okay? Managing HR in-house is overwhelming. That's why we built the People Processes Advisory System. Start with our free HR resource library, get instant access to policies, guides, and compliance checklists. The templates are just the beginning. Run our Strategic HR Audit to scan all your key domains for your people processes. In just a few hours, we'll work through and identify your compliance gaps, and my team will generate a custom roadmap for you, meet with you, and show you exactly what to fix step by step, ready to execute. Use our toolkit to generate job profiles, deploy policies, track employee documents. You're not alone. You're backed by a 5-star expert team supporting over 10,000 employees nationwide. Be your team's secret weapon. Visit advisor.peopleprocesses.com to start your free account today. Well, I'll give you one more kind of example on here. This is McPherson versus EF Intercultural Foundation. It's in California. The employer had an unlimited PTO policy. No accrual, no cap, take what you need. The employee was terminated and demanded a PTO payout, which is required in California for vacation. The employer said there's nothing to pay out, PTO is unlimited, so nothing accrued. This is common and one reason why people do unlimited PTOs. The court, however, in this case disagreed because the policy language created an entitlement, because it was a will, because it was a direct language. And the employer failed to show that it had truly unlimited discretion. So, the way you describe your PTO policy in your handbook determines whether it creates a payout obligation at termination or not. States with mandatory PTO payout laws, California, Colorado, Illinois, if your handbook creates an accrued benefit, you must pay it out. Unlimited PTO doesn't automatically mean no payout obligation. It depends on the language. Will receive, right? You're creating a true obligation. You promised to do it. If you're offering unlimited PTO, the handbook must explicitly state no accrual, no vesting, no payout at separation, ability to change this going forward, right? Track whether employees are actually using the PTO as well. If they're not, unlimited is really zero and you have a bigger problem, just a side note. And then also, these new a lot of companies love this unlimited PTO thing, but there's a major issue there, which is FMLA complications. If your PTO is truly unlimited, every FMLA leave could be argued as fully paid leave. So make sure that your unlimited PTO policy addresses long-term leaves of absences. Otherwise, you're going to pay people for 13 and 16 weeks. All right, 12 weeks, whatever you got in your state. All right, I know those were some side notes. State requirements and unlimited PTO, they just come up when you're looking in your handbook. But let's go back to the core. Step 1. A couple things I want you to do. Audit your disclaimer this afternoon. Pull up your handbook, find the at-will disclaimer. Is it on its own page, in bold, signed separately? Does it disclaim all contractual obligations, duration, procedures, and policies? And do the employees sign a separate acknowledgement form? If the answer is no, fix it first. This is your foundation. Step 2, run the 6-word search. Search your entire handbook for will, always, promise, shall, permanent, and guaranteed. Every hit is a potential contractual obligation. I often see permanent employees as a type as well. Get rid of that. That's not a word that you want to ever use. Replace those with permissive language. May, generally, at the company's discretion, reserves the right, etc. Pay special attention to your progressive discipline, PTO, benefits descriptions, and termination procedures. Those are the ones that most commonly I see these kind of words in. This isn't wordsmithing. It's the difference between a policy and a contract, so pay dang attention. Okay? Think about consistency. Your at-will disclaimer says no contract. Look through your handbook to make sure that there are no contractual words in there. If not, fix it. All right, next up, while you're in there, look for your state-specific requirements. Okay? List every state where you have employees, including remote workers. Check whether each state requires specific handbook provisions, and then make sure they're in there. If you don't know where to start with that, please reach out to us. We'll be happy to help. We have a state-by-state checklist, I think, back in episode 73 to give you some ideas on there. Step 5, build an annual review cycle. You got to look at this every year, normally fourth quarter, to prepare for January 1 changes. and require new employee acknowledgments after every update. Track your version numbers and effective dates and who signed what. It's a difficult project. It takes some time, but you can always work with a company like ours or an attorney. They often charge $3,000 to $5,000 for an annual review, not normally your first one, but kind of your renewal side of it. It's just something you got to budget in, or work with a company like ours that can handle that as well. There's a big cost to getting this wrong. Wrongful termination based on a handbook promise is easily going to be a year or two's salary, $50,000 to $500,000, and that's if you're not doing anything wrong. Class actions over inconsistent PTO payout, easily $500,000 or more, significant portions of your payroll. Missing state required provisions often have single violation per violation issuances, like for every employee you didn't tell about this, $500. And then that unlimited PTO payout drives me crazy. That can be back pay, waiting time penalties, attorney fees. Be careful when you're using those. Whereas doing this can take you a couple of hours in the afternoon to get you 80% of the way there. If you want a consistent process, reach out to us and we'll be happy to help. I've put together a handbook audit checklist for you. It's at advisor.peopleprocesses.com. The link is down below. It includes the disclaimer effectiveness test, that 3-factor analysis we walked through, contract language finder, consistency cross-reference guide, and some of those state-specific mandatory provisions so you know what your state requires. And if you want someone to look at the whole picture, not just your handbook, but all 18 domains of HR compliance, we have a strategic HR audit where I look at what you're doing across those 18 domains, identify deficiencies, give you a plan to fix them. It's normally a $2,000 plus assessment that covers everything from hiring to termination. If you go to advisor.peopleprocesses.com and sign up there, that's where you'll download your handbook audit checklist. It's free on there, has all our episodes and tons of free resources. But if you click on audit and click strategic audit, it'll take you to a checkout page, and you can use the code EP74AUDIT. That's episode 74 audit, EP74 audit, Echo Papa 74 audit. Use that, and the first 10 people in the US who have more than 10 employees, I'll do the strategic audit for free. Okay? That's $2,000 for each person who wants to do that. Episode 74 audit. Go on to People Processes. Go to the link below, advisor.peopleprocesses.com. Click audit, strategic audit. Use that checkout code. Your handbook should be your shield. It's the document that protects your business when things go wrong. But right now, for a lot of employers, it's the plaintiff's best evidence. Fix the 6 words, fix your disclaimer, and make sure your practice matches your paper. And don't let your signature be the contract, you let your handbook be that contract that's going to mess you up. Okay? Let it help you. Ladies and gentlemen, thank you for tuning in. Again, my name is Rhamy at People Processes, and I appreciate your time. Now it's time for you to go out there, have a great day, and get your work done.